Hello, Alison. How are you?
I'm good. How are you?
I'm fine, thank you. Very nice to see you again. And we're continuing with the sex assault series. This is a bonus episode, just because we've been receiving requests to address specific issues when it comes to sex assault cases. And they're really important points. And that's why I thought that it would be really interesting if we can record this bonus episode. So thank you for taking the time. I know you're very busy. Uh,
Of course.
and there's a lot going on in sports right now, which is equally important for you. But thank you for your time today. Yes, Allison. So, we're going to be covering here today two things. It's dealing with the complainant in a sex assault case when the complainant is a minor, and then the bald denial defense. So we're going to
Correct.
start with the complainant as a minor, and we're going to approach it by focusing on two aspects. The complainant is a minor at the time of the incident, but she's still a minor at the time of the trial. How to deal with her in that set of case. And then when the complainant is a minor at the time of the incident, but she is an adult at the time of trial. So let's start with the complainant minor all along.
Um, so a couple of things. Just as a sort of a general proposition, whenever there's a child witness,
Mhm.
um, conduct yourself accordingly. You're never going to win any bonus points with a judge or a jury by traumatizing or yelling at or being rude to a child. Like you really, the term kid gloves, you really have to use kid gloves with child witnesses, because whether or not they're actually a victim of what your client is accused of, something traumatic has obviously happened in their life to land them in the witness box in a criminal court. So be very, very careful about how you deal with them. For young children, I mean, the reality is they are generally very, very susceptible to your suggestions.
Mhm.
You can suggest pretty much anything to a young child and they will agree with you. So I don't want to say they're easy. That's not fair. They're not. But
Gullible,
um
kind of?
yeah, they're very
Mhm.
vulnerable to suggestion. So often when you put things to a young child witness that's part of your client's defense, they're likely to agree with you. Um and children sort of the same issue, but from a different perspective. Children are very suggestible. Um, and there are things like parental alienation syndrome that you have to consider. I don't want to say very often again, but it's not impossible that a child has made this complaint because someone, suggested to them something had happened, an estranged parent, whatever, and that's what got them there. So, the susceptibility of, or the suggestibility of children sort of goes both ways. There tends to be pretty easy to get to agree with your suggestions,
Mhm.
and there also may be other reasons why they're in the witness box and making this complaint other than it actually having happened.
And I mean, sometimes we could guess what that reason is, either because the child is related to the accused or they know each other, so our clients can tell us
Yeah.
how, like the mother taught them or told them or coached them. But sometimes if they're strangers or they don't really know each other, we don't really know. So,
Right.
what do we do in that case?
Um, Their memory, right? Very often I find that the statements that police take from child witnesses are very sort of short and basic. Like they don't get into a lot of details for obvious reasons. They're dealing with young children.
Mhm.
So if you really try and push to get more details about what the child says happened, they're probably going to be unable to provide them. It's going to be a lot of I don't remembers or, changing stories, that sort of thing. And so that's another way to challenge the credibility and reliability of a child witness successfully. Push on the details, they're not likely to be able to give them to you.
But is that also because they are children or
Yes,
okay. Uh
absolutely. And we know. broadly speaking, the courts have been told you have to keep their age in mind when you're assessing their credibility and reliability.
Yeah.
And, children don't think and remember the same way adults do. But realistically, if a child is basically saying, I know he touched me, but I don't remember anything else, that's not going to be enough for a conviction. So we know what the law says, but practically speaking, if they're unable to provide any details, you're not going to get a conviction.
Now, the other issue as well is when they're describing the sexual act, because um, obviously if they're describing something that's very graphic, I mean that gives them kind of credibility, especially if they're very young and they're saying, oh no, 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 he touched me here, he did this.
Mhm.
It's going to be very difficult for a judge to say, well, this is all invention or creation or somebody taught them. Like this is probably something that they've experienced if they're describing something as graphic. Um,
Yeah, potentially. Yeah, definitely. That's definitely true. But I would also caution that um, when you're watching this, because usually the statement of a child goes in under 715 and they don't
yes.
testify in chief. They just put their
Hmm.
video statement in. There are so many occasions where the officer, either intentionally or unintentionally, when they're taking a witness statement from a child, suggest to them like leading questions. They're basically, well, didn't he touch you here? Or did he touch you here? And, on and on it goes. And so you have to caution the court to be careful about that as well. Is this something that the child is actually saying and remembering? Or are they just agreeing with all the suggestions or questions put to them by the officer? Because those can be two obviously very different things. So it's pretty rare that a child really, and I guess I'm speaking, 10 and under, for example, can really provide graphic details. That doesn't usually happen. They usually provide generalities and then sort of agree with an officer when they're making a bunch of extra suggestions. And to me, that's not very cogent evidence when it's just yes, 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 to all the officers' questions.
Well, and the problem in many of these cases are the parents, because those cases get reported usually by the parents, not by the children. It's the parents are having a conversation one day with the child, and then the child will say, "Oh, this guy touched me here," and then the parents will keep asking questions, and then they'll say, "Oh, okay, so my child has been sexually assaulted," and they call the police. So, how much also is the parents' evidence here? Important to deal with as well.
It is. It's either the other one that you see very often is the school. I've had
Right.
so many
Yes.
cases where it's the
Teachers.
teacher or the guidance counselor or
Exactly.
someone that reports it. So yeah, their evidence will be relevant and admissible. But more often than not, I swear it's got to be 95% of the
Yeah.
time, when a complaint is made in those circumstances, either to a parent by the child or to a teacher or someone at school, it's because the child has gotten in trouble. Like every time.
Hmm.
They got in trouble at school. They brought a knife to school. They, came home late, or well, I suppose that's an older child, but you know what I mean. That it's they're making this allegation after something has been alleged against them. I
Right.
swear it's almost every time.
Yeah.
And that can provide a motive to fabricate, right?
Hmm.
Is that the child has gotten in trouble for doing something and they're passing the buck, passing the blame, making something up potentially to earn sympathy to get out of the trouble that they're in. So, the evidence is important, but it can also be very helpful in a lot of the
Right.
circumstances.
And well, especially if it's children and the parents are the mother or the father is connected to the accused and there's a problem
Right.
between them. So it's that other adult using the child against the accused and making them say that there has been something, a sexual assault that happened. That can also,
Exactly.
and this
Yeah.
all
It's
goes,
very often in when there's, family court proceedings,
yes.
suddenly an
Yeah,
allegation arises against the other parent. I
exactly.
just last week or the week before, I guess, I was on a panel at the Superior Court Judges Conference about just that, the intersection between family law and criminal
Yeah.
law. And it happens all the time.
Right.
So that's something to watch for as well. What's going on behind the scenes with this family if it's, family
Exactly.
members that are involved?
Yes, and domestic violence cases as well are very much the same. All right, so this is when the complainant is a child at the time of the incident and is a child at trial. Now let's move on then, Allison, to the situation where the complaint at the time of the incident, the complainant is a child or a minor, but then at the time of trial, she's an adult or he's an adult. So here it's different. There's the memory issue that comes into play. So how do we approach it here in this situation? And of course, here we're dealing with an adult, so we don't have the sympathy kind of aspect when we're dealing with a child witness. But it's in relation to her evidence or to what happened to her or him when they were children. So,
Those ones I find can be harder because
mhm,
sometimes there really is a question about motive to fabricate. Like, why would you be coming forward and saying this 40 years later if
yeah.
it didn't actually happen? But first of all, reliability and memory obviously is going to be a huge issue, and it's going to be, generally speaking, a hurdle for the Crown to overcome. Um, and I find often in those cases, if a lot of 278 issues will arise in both situations, when there's a child making a complaint about, recent complaint, and when a grown adult is making a complaint about a child. Um, just before I move on to what we're talking about now, keep that in mind when you're dealing with a child making an allegation. There's almost always going to be CAS records you might want,
Hmm.
school records you might want, therapy records you might want, those sorts of things. So keep that in mind. But then when it's an adult making a complaint about something that happened long ago, usually the police are not the first person they told about it.
Yes,
Often it's something that they spoke to their therapist about first, or they
exactly. Yeah.
spoke to their doctor about first, or whoever. And those records can be relevant and are something you should probably seek. Um, and so that's something, I mean, again, I think I've gone on this rant before about not having preliminary hearings to explore these
Yeah.
issues anymore. But in the good old days at a prelim, I would ask, have you ever spoken to anybody else about this? Who did you tell first? Blah, blah, blah. That's something you should be asking at a trial. And if a mid-trial 278 application is necessary, so be it. Um, Parliament in their wisdom, getting rid of prelims is going to have to, accept that that happens more often than not, I would say. So, um, focus on their memory, focus on any medical conditions they might have that have affected their memory. Often these complainants are experiencing various mental health issues. What drugs are they on that could affect their memory? Those sorts of things. You should dig into it and explore all of that, as well as who they disclose to first in terms of professionals, and maybe go after those records.
Now, the frustrating part in these cases is that we know we can't use the argument that why didn't you disclose it back then? Like, what took you so long to? I mean,
Hmm.
that's not something that we can rely on. I mean, this is
No.
justified and courts disregard that. So, but I mean, if we are talking here common sense, um, why don't they? Like, like that it
Yeah.
is a frustrating point here. It is something that if it was really that traumatizing, like why didn't you just do something right away? Why is it all of a sudden now? And I find that it is related to the motive
Yeah.
aspect as well. So are we still able to make or use that element in a way that is not contrary to how the courts either instruct the juries or or a judge would remind themselves, how to or caution themselves about this issue.
Yes, but in a different way.
Mhm.
So you can't just say to the complainant, come on, ma'am, if this had
Yeah,
really happened, you would have reported it 40 years ago.
yeah.
But you can focus on what happened recently that led to this complaint, and that's a perfectly reasonable way to go about it. So focus on why now rather than why not back then,
Hmm.
and then you're safe.
All right. And so if we want to come back, Allison, just to the 278 and all these records that we want to get in these types of situations, let's talk a little bit about them because these are a very, like, it's a battle when we get into these records, and especially when it's a youth, when it's someone who's young. Because that's another issue that we also have to be mindful of, that when it's someone who's young, um, under 18, we can't just have access to their records just like that. So it's
No,
maybe easier for an adult, but not for a young person.
right.
So let's talk a little bit about that because it's a bit of a challenge.
It is a bit of a challenge, although I find um, what often happens, particularly when it's a complaint that's made at school, u- usually the police will go and take statements from whoever was involved
School
in receiving
teachers,
this
yeah.
complaint. Exactly. Um, and it's often based on those that you get the basis for the 278 application because the way the teacher describes, or whoever at the school describes what the child told to them, um, often will produce inconsistencies that would support a 278 application. Or they will be explaining, well, the reason this came up is because I brought Bobby Joe into my office because Bobby Joe was found with a knife and we started talking about et cetera, et cetera, et cetera. And you have there, I think, an obvious basis for a 278 application because you've got evidence of motive to fabricate. And you need to know the details about what led up to this child's disclosure that could support a motive to fabricate. So often, particularly when it's a school employee, their statements to the police, which are obviously disclosable, will provide the basis for the 278.
All right. Um, but here again, one other thing that I also wanted to ask you, Allison, because you did address how to deal with them when they're young complainants and they come to court. The other layer or aspect to that is when we're in front of a jury. So, I mean, still, it's the same considerations, of course, it's
Yeah,
still the same thing. But when we're dealing with a child and it's a jury and they start crying, because I mean, again, the difference between a judge alone and a jury is that judges have been in trials before, so they know that
yeah,
these things happen. Juries, maybe not. No, I mean, they're asked questions about whether they've done this before or not, and then they're not, like, maybe when they see a child crying, that gives credibility to the child, that the child obviously is telling the truth. And it may not be that they're crying because of that. They're just simply crying because it's a lot of pressure, it's long, they're tired, they're not used to testifying in court. So they're crying because of a completely different reason.
right.
So, but how do we handle that in a jury trial?
Exactly that. Put other things be very sensitive. Like deal with the child as if it's your own child crying,
Hmm.
honestly. You
Yeah,
really want to look like you're extraordinarily sympathetic to whatever
yeah,
the child is going through. You can put those suggestions to him. It's been a long day and you're finding that really upsetting, isn't that right? You like very sensitively, and they're going to agree because they're children,
yeah,
99 times out of 100,
yeah.
which goes back to what I was saying at first. So, just put to them other things that they are upset about and is making them cry, and that'll sort of neutralize that.
Now, on the other hand, though, how about, like, what tip do we give to the lawyer who is, because it's not easy for us as well, I find, like,
Yeah.
because sometimes some of these kids are really cute. They're really nice. They're really, like, very, they're kids at the end of the
Yeah.
day. And we're human
Yeah.
beings and we're doing our job. But sometimes, even for us, on the other hand, like, I don't like, to be honest, when I'm cross-examining a child, and especially when I feel like the child is starting to get, tired or doesn't like this. So for lawyers, though, and especially for newer ones who have to, because it's not easy, but what
No, it's
advice
not.
would you give them when they're, on the other hand, on the other side, they're cross-examining this child and they're starting to feel like this is tough, this is difficult. Like, what do I do?
Yeah, I mean, first and foremost, remind yourself that you are just there doing your job.
Yeah.
You're first and foremost, your obligation is to your client. And sometimes that's just going to be difficult and you have to, do a difficult job. But I I find it doesn't really affect me when I sort of pretend like I'm not in the trial as well. You know what I mean? Like I sort of pretend like I am just having a conversation with an adorable
Hmm.
little kid. And um, if I think of it that way, and I'm not yelling and screaming and,
Right.
being mean to the
Yeah.
child, um, it's much, much easier to deal with. Just pretend it's just, you and the child having a conversation in the playroom somewhere, rather than in a courtroom.
So, and that goes back again to what you were saying about the tone,
Yeah,
that if you adopt a tone that is not aggressive or adversarial, it doesn't mean
exactly.
that the questions are not questions that you're trying to get the information that you want. But if you're just approaching it, like you said, like this is a conversation between you and the child, then that will give you a better, let's say, connection or a better
Exactly.
cross with the.
You'll get a better connection with the child, you'll get a better connection with the jury or the
Yeah,
judge. Everybody will appreciate you dealing with the child sensitively, and you can still be just as effective doing it that way,
right.
if not more effective.
Exactly. And because if you think that the child is adorable, most likely the jury is thinking, like, what a cute child, and
Exactly.
why are they doing this to them? Why are they torturing them? So,
Exactly. Yes.
okay.
Be very cognizant of that. You can get, I mean, if you are aggressive and adversarial with a child, they're often going to shut down.
Yeah.
If you are friendly and, speaking like a kid on kid conversation, friendly with the child, they're much more likely to answer your questions and give you what you need in order to successfully defend your client. So, you're also much more likely to do a good job for your client if you deal with a child the way they should be dealt with.
All right. And what else, Alison, would you want to add to this area of when the complainant is a minor that we need to be mindful of?
Thing I would say is, generally speaking, there's going to be a sexual interference charge along
Yes.
with a sexual assault charge when
Yes.
you're dealing with a minor. Those are preliminary hearing eligible.
Hmm.
Take advantage of that.
Yeah.
Unless you're in a jurisdiction where the Superior Court is a complete horror show and you just have you will not win a trial in Superior Court. Um, Take advantage of the preliminary hearing because a child, I mean, you think our memories as grown adults, change and fade and that sort of thing. With a child, it's tenfold. So if you're asking them questions at a preliminary hearing and they're 6 years old at the time,
Yeah.
and then they're 7.5 at the time of a trial, you're going to have a gold mine of
Yeah.
inconsistencies to work with. So um, if you're dealing with an allegation when the complainant is a minor, take advantage of the preliminary hearing and
That's true.
encourage your clients to do that because it can make all the difference in the world.
Yes, that's a very important point. But then again, also on the memory aspect, though, when we get to submissions and we want to rely on this memory gap, I mean, yes, inconsistencies, we like when there are inconsistencies between the prelim evidence and the trial evidence, but in the case of a minor, it's more understandable. Like it is more expected that they don't have the a memory like adults, or they are like, I mean, there's more things that they can get away with in their evidence. So
For
how do
sure. For sure. But you know, was his sweater, green or purple? Fine. Okay. We can
yeah,
excuse the memory problems there with a child. But when it comes to sort of the basics of the allegations, I find that if those details change, a judge is going to be much less forgiving, regardless of the age. So there's still likely to be really good stuff there to help you with your case.
all right. But and also, and one other thing that I wanted to cover when it comes to minors, or especially when they're very young children, sometimes it's also the language. Uh, they may say something that, let's say, the teacher or the parent might interpret as being a sexual assault,
Right.
but it's not. It's just because it's baby talk and the way they say things or the way they explain it may come across for someone who's wired to see sexual assaults um, everywhere, to think
Exactly.
that, well, this is a sexual assault. So this child here at school, especially if it's a teacher, the parents may know how their children speak at home, but the
Yeah.
teachers, they hear the child say, "Oh, my uncle touched me there." And then they'll be like, "Oh, that was a sex assault." So, um, and it's just like a language, like a child language thing. So, how do we deal with that as well?
Uh, Poke and prod around what they mean when they say that.
Hmm.
It'll become obvious when they say it, but yeah, if I'm trying to think of an example of something a child could say, I know what you mean, but um, I just ask them for more details. I mean, that's really the best advice I can give, and it will generally become obvious that what they are describing is not what the police or the
Hmm.
Crown interpreted them to describe. Because
Right.
again, witness statements are generally with children so vague and short. Um, it may not be obvious at that point, particularly if they're just echoing, a phrase they heard at school or whatever. But when you really get more and more details, it more often than not will become obvious in the situation you're describing that it's not a sexual assault at all.
And also the other thing, the other challenge that we may have with children is that unlike adults, they don't necessarily have social media accounts, especially if we're dealing with very young ones. Because if we're
Yeah,
dealing with someone, a child where I mean, your client is always the one who's going to give you the most information about the complainant. But in some situations, they don't really know the complainant that much. It could be a neighbor. They'll say, "Well, I left my child with him for a few seconds, and then this is what he did," but they don't really know much about them. And you can't
right.
discover much about the child and their history and their trauma through social media. This is a whole aspect that's missing as opposed to an adult complainant. So, for the getting more information, because like you said, sometimes what brings the complainant to court is some kind of trauma, not necessarily the incident, the sexual assault, but some other kind of trauma. And what we want to do is we don't want our client to be convicted because of a trauma that is not a sex assault, but a personal trauma to the child. So when it's a child, Alison, and you want to get more information, you want to know, and you're starting to think that maybe there's something else going on. It's not a sex assault, but there's something else. But how do I get that information without this social media
I have on more than one occasion retained a private investigator to
for
sort of dig
children?
around the family.
Okay.
Yeah. If I suspect that, there's something else going on in the home or in this child's
Hmm.
life. And that's my go-to is the private investigator. But then also if you start asking the child about who they've spoken to about this and that sort of thing, you'll potentially find out records that you can go after to dig further into what happened beforehand. Like school records tend to be very thorough. CAS records tend to be
Yeah.
very thorough. You can just ask the child, who's been in and out of their life recently and, who do you spend the most time with? And it'll often become obvious if they're, families involved with the CAS or something like that. And that can open up a million cans of worms. But if you have a spidey sense that there's something else going on with this family, get a private investigator. The child may not have social media, the parents might, the siblings might, those sorts of things. You can often dig that way without needing the child's social media account directly.
All right. And of course that goes back to the point that you made that prelims are very helpful for that type of situation. So if
Yes.
it is a case where there is the opportunity to have a prelim, you should definitely take advantage of that opportunity.
Definitely. Whose house do you spend the most time
Yeah.
at? Who picks you up from school? Like all those sorts of things, you can really sort of get a bigger picture of what's going on in the child's life.
And sometimes there is a sex assault, but it's not the accused, it's someone else.
Yes,
But what happens, especially when it's a child, whoever does something that they don't like, they'll say, oh, whatever bad experience happened with that person also did it because I don't like them. And they associate things sometimes
very
with
much
other
so.
people. All
Yes.
right. So let's then move on to the other aspect that we wanted to cover, which is when it's a bold denial, is the defense like nothing happened. So what do we do here?
Prepare your client to testify
Okay.
really, really well. That's the most important thing.
Yeah.
Yeah, I mean, in a broader sense, they're not that different. You're still focused on the credibility and the reliability of the complainant. Um, but again, a bald denial in any sex assault, your client is generally, at least the way I practice, going to be testifying, whether it's to say it was consent or whether to say she's nuts, this didn't happen. Um, so it's you're still focusing mainly on how you can impeach the complainant and how you can best prepare your client to testify and potentially other defense witnesses. Like sometimes when it's an issue of consent, there generally aren't going to be any other witnesses that you're going to want to call because
Yeah.
the bedroom, nobody else is there. When it's a bald denial, sometimes there's other people that you can call as defense witnesses. They were at a bar one night and there was a big fight and the complainant stormed off and then later made this allegation. There probably were a group of friends at the bar. That's just one example. But bald denial cases may open up the door for more defense witnesses who can provide evidence about whatever was going on the night in question or between the couple or whatever, um, to provide more detail and motive to fabricate.
A little bit like what we saw during the hockey trial as well. I mean,
Yeah.
there was a lot of other information. We had videos before they got into the room. We had messages that were exchanged with the groups, and there was a lot of other type of information as well that kind of
Yeah,
helped.
big time. Like I did a case not too long ago where trying to remember all the details, but essentially there was a group of acquaintances or friends that were out. The complainant wanted to, have a fun night with the accused. My client said to a friend, basically, she's too ugly. I don't want to sleep with her. And that got back to the complainant. And then she went to the police and made this allegation about sexual assault when
Hmm.
nothing had happened for the sort of nasty reasons that my client had said. But there were all these people there that were witness to this conversation and how upset the complainant was when she was told by, the mutual friends that my client didn't want to sleep with her because of her
Was not
looks and
attracted to her, yeah.
exactly and were witness to her, fury at that and, storming off and et cetera, et cetera. So I called, I don't remember, two or three witnesses to just this conversation to provide evidence about why she had this reason to fabricate the allegation. So that's just one example, but often there will be more meat on the bones, so to speak, that you can call to support your client's version. Not always. Sometimes you just have to have a very well prepared client. But um, one one thing that I've had a few times, and you've got to be careful that you actually believe your client when he says nothing happened,
Hmm.
because otherwise you can sort of get yourself into trouble. But very often, if you believe your client and are confident that it really didn't happen, things like tattoos that the client has that would only have been seen if they were in fact, unclothed in a room together. Unique features about your client's genitalia.
Hmm.
I kid you not. Very often there are things
Yeah, no,
about
but that is
them.
really important. Yeah.
Yes, that if there had actually been a sexual encounter, the complainant probably should be able to describe. Things like that, that you can ask the complainant if they can't answer. Well, it's because she never saw him with his clothes off. Now, be careful because God help you if they can answer. So that's why I say you've got to be sort of really confident and put the gears to your client and test them, I think, first before you ever start asking the complainant those sorts of questions. But um, if you're confident that the complainant's not going to be able to answer them, those can be excellent things to explore.
So that's a very important point. But one thing I want to ask you about that is how do you actually make sure that you're really getting the truth out of your client? Because honestly, sometimes clients will lie even to their
Oh
own
yeah,
lawyer. So, but
often.
that is the most difficult part
Yeah,
because like you said, if you get that information from your client that they have something very specific, very unique, that only if they were in a very, very intimate situation, they would know. So
yeah,
that's really very important. But like you said, you want to make sure that this is really true, that whatever your client is saying about the incident is true. But how do you get them to, or how can you know, even if the client insists, oh, no, no, I'm telling you the truth, but they're lying. Sometimes, even when they insist they're telling the truth,
yeah.
unfortunately, they don't.
Uh,
Um,
Number one, check the DNA results,
okay.
if there
Yeah.
were any. But I think we've talked before about what I think is the most important part of any client preparation, which is a mock cross-examination,
Hmm.
right? Bring in your colleague or whoever
Yeah.
to do a mock cross-examination of them and like have them be vicious, like the most mean crown you'll ever deal with. And that'll give you a pretty good idea. Trust your spidey sense. We usually know,
Yeah.
I think realistically, whether our clients are telling us the truth or not. Um, but I think the best way to sort of satisfy yourself is to put them through a mock cross-examination before you ever start putting these sorts of things to the complainant.
Mhm.
And that's as confident I think as you're ever going to be. You're never going to know for sure, but put them through the ringer.
And it's very important, as much as possible, like you said, to make sure that you are getting the real picture, the true events that really happened from your client. Because if you have something like that, that can be a very important and powerful cross-examination because you're
Yeah.
really directly showing that, well, obviously she's not telling the truth, she or he. I mean, I don't want to like
Yes,
sometimes even a
exactly.
male can be the complainant and the victim of a sex assault. Um, so that's something that we also need to be mindful of is that we want to make sure that you get as much as possible the truth from your clients before you start cross-examining them. What else, Alison, do we need to cover here about this as well?
Fault denial cases are maybe, I don't want to say the best, but I keep coming back to the issue of private investigators.
Hmm.
But it really is something to consider. They can pull up a lot of dirt in, I don't mean that in a derogatory sense, but they can pull up, generally speaking, a lot of information about the complainant that you're not going to get from the Crown in disclosure. Consider whether or not that's something that you should utilize. If you're just sort of all out of ideas, you don't have anything to work with, there's no obvious motive to fabricate, try that. See if a private investigator can, pull up something useful. But otherwise, the best thing you can do is just be overly prepared for the cross-examination and have your client overly prepared to testify. It's back to basics, but that really is the best thing you can do. Have your client, because, if your client, regardless of the complainant, if your client is a credible and reliable witness, the judgment is likely to go your way. That's the bottom line. So you don't have much to work with, fine. But if your client is the best bleeping witness that the court has ever seen, it's going to be a really difficult thing to convict him.
That's true. Because at the end of the day, if the judge or the jury believe him, or her, they are going to have to acquit them.
Exactly.
And the thing is, just to go back on the point that you made about the private investigator, I think it will be even more important where you can't see an obvious motive to
Exactly.
fabricate, because the thing is, in these cases, most of the time there is a reason why a complaint is
Mhm.
being made, and especially when they're strangers, they don't know each other, and your client insists that nothing happened, there's usually something. So if
Yeah.
it's not apparent in the disclosure, why? Because sometimes just from reading the facts, you can understand or you can assume why this complaint was made. But if you don't, I think that will be a very good case to actually hire a private investigator. And I think we did
Yeah.
mention that some of them do work on legal aid rates.
They
So you can
do.
find, so it's not because it's a
Yeah.
legal aid case that you'll say, oh, well, my client doesn't have the means. You can still find some that
And
can help.
legal aid will almost always fund it,
Yeah.
because they're relatively inexpensive. They're not going to give you, unless you can give them details about what you're expecting the investigator to uncover. They're not going to give you 100 hours, but they will give you some hours for a PI to at least start digging. And then often will give you more if they come up with something that they want to follow up on and that sort of thing. So it really is worth the investment. If nothing comes of it, so be it. But it didn't cost you or legal aid more than 200, $250.
All right. And so this is a really important advice. I think that was coming out throughout the series that the use of a private investigator can be very important in these cases, as well as the preliminary hearing when it is an option to really, really take advantage of them.
Yes, 100%. Preliminary hearings are my favorite.
Yeah.
They will help you win your case every time.
All right. Anything else? Any final thoughts, Allison, before we end this bonus episode?
I don't think so, but I'm always happy to come back and answer more questions if people have them.
Perfect. Thank you so much for your time. And this is then the bonus series episode for the series Sexual Assault. So if ever there's anything else, as you said, you're happy to be here, and I am always happy to interview you about that. So hopefully I'll see you again for that.
We will. We'll do it again.
Thank you.